Welcome to the Burnett Breakdown, where I, Hunter Burnett, keep up with the news so that you don't have to. This week, I'm going to be talking all about the Supreme Court cases. So this week, the Supreme Court released its opinions on 4 pretty significant cases. So we're going to talk about them as they were released. So that means that the first one of the week, released, I believe, on Tuesday, was Moore v. Harper. So, Moore v. Harper. This is one that kind of did not really get a whole lot of headlines, especially not compared to the ones that we'll talk about later in the week. But this case dealt all with basically the power that legislatures have over districting, over drawing district maps. So this case was all about district maps drawn up by North Carolina's Republican-controlled legislature after the 2020 census. So after the census every 10 years, population changes, so states have to redraw their congressional maps to accommodate the population changes that occurred over the 10-year span. This map that the legislature drew was challenged in 2021 by Democrats that this map was politically gerrymandered, and that because it was politically gerrymandered, it violated the state constitution. So this case went to the North Carolina Supreme Court. The North Carolina Supreme Court ruled that it was indeed politically gerrymandered. Therefore, it violated the state constitution. So after the Supreme Court made that ruling, they then appointed 3 experts to redraw the congressional districts. Okay. Now, Republican lawmakers in North Carolina then appealed to the Supreme Court. They said, basically, they argued that the U.S. Constitution, specifically the U.S. Constitution's election clause, gives state legislatures, and this is the important part, state legislatures alone, the power to set federal elections rule. So this is what is known as the independent state legislature theory. Again, the theory goes that the state legislatures have the power, and the state legislatures alone have the power to draw congressional districts, according to the U.S. Constitution. So basically, what this means and would mean, if the independent state legislature theory was correct, that any federal election law passed by a state legislature could not be reviewed, struck down, or altered at all by a state Supreme Court. So at issue and at stake is really whether judicial review, whether a state's Supreme Court had any power over federal elections laws or not. So this case, it kind of was in the headlines and was making news because of its potential for the 2024 election, especially in light of the 2020 election. Part of the fear of many was that states with Republican-controlled legislatures, or vice versa, with Democratic-controlled legislatures, that they could, let's say, the Republican candidate lost in 2024, but we kind of have a repeat of 2020 where the 2024 candidate is claiming the election was stolen because it was stolen and corrupt in the states. The state legislature should act, and let's say that the state agrees, and the state legislature I guess it would have to be a swing state, so we'll say Georgia, the Republicans in the Georgia legislature pass a law that the Republican candidate lost the Georgia election, but it was full of corruption and fraud, and so they pass a law that gave the 2024 election to the Republican candidate. Well, the question becomes, could they do that, right? And theoretically, under the independent legislature theory, they could, because there would be no review, no judicial review. The state Supreme Court couldn't come in and say that's unconstitutional, and the Supreme Court couldn't do that because it's a state election, and they don't have any power really over state elections theoretically. And so that is what, or the Supreme Court could say they have authority over the state election, but then they would have to get caught up in the political mire of the 2024 election. They'd have to be making those decisions that putting them kind of in the political spotlight. So in this opinion was written by John Roberts, Chief Justice. It was joined by Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson, and then Thomas, Alito, and Gorsuch all dissented. So what that means is John Roberts, along with the majority opinion, basically put a nail in the coffin to this idea of the independent state legislature. They all basically, the opinion basically just exploded this idea that John Roberts, in his opinion, went back throughout the history of the United States, claimed how the judicial review was central to American history, has been central to American history, and that applies to the states as well. I don't really have much thoughts on that or not. I think in some ways, I see his point. I see that judicial review really is central to American history. I also think that the system of checks and balances of one political branch having basically unlimited and unchecked power was never in the framers' intent, especially not the federal Constitution, but even in the states, that just wasn't really a thing that you saw in the states. And so the kind of the idea that a legislature would have just unchecked power to make federal election laws, I find would be suspect. That's the suspect, a suspect theory to begin with. However, at the same time, the legislature is the most powerful branch, and I do think courts can use judicial review and overstep their bounds. And John Roberts, in his opinion, kind of tried to thread that line and basically say, because what could happen is state legislature passes an election law, and the Supreme Court of that state, maybe they're of a different political persuasion, steps in and completely rewrites the law. Okay, well, they're unchecked now, right? They can't do that. That's an unchecked political branch being able to wield power. So at the same time, you don't want judicial review to go overboard. And so John Roberts, in his opinion, tried to thread that line and essentially say, but at the same time, courts can't go overboard or we will step in. Now, I say all that, but Thomas, Alito, and Gorsuch all dissented, not on the basis of the merits, although Thomas did write some about how he disagrees with the merits. But they dissented because the case was now moot, meaning it was pointless to even rule on this, that the issue at stake was now over. And it was over because earlier this year, the North Carolina Supreme Court overturned its ruling to redraw the map, which means that this whole issue is now irrelevant. And so Thomas, Alito, and Gorsuch's point was, why are we talking about this? Why didn't we just say, okay, the issue is no longer an issue, so let's move on. We don't have to rule on it. And I actually completely agree with them there. The issue is moot. They shouldn't be ruling on it if it's moot. The second case got a ton of headlines, as it was all about affirmative action. So these were two separate cases that were combined into one. The justices had to determine whether the race-based admissions policy at Harvard and UNC violated Title VI of the Civil Rights Act and the 14th Amendment's Equal Protection Clause. So affirmative action is essentially the idea of race playing some role in admissions to colleges or a job or etc. The idea being that in order to correct past wrongs, we have to take into account race now in order to kind of level the playing field. Chief Justice John Roberts wrote the opinion again, except this time he was joined by Alito, Thomas, Barrett, and Kavanaugh. And Gorsuch all joined the opinion. So the schools in there argue for why they even use race. They say that they use race because it ensures that they have a diverse student body, which they view as essential to the educational experience. in some ways, you can see their argument in the sense that a diverse learning environment is essential to an educational experience. If all you're doing is learning the same thing over and over and over again, you're not really, it's not much for education. And so having a range of diversity is important, and they argue that because that's an important goal, and a goal that goal makes it so that they have to consider race into their admissions policies. The majority, though, concluded that this still violated the Civil Rights Act of 14 and the 14th Amendment because it necessarily discriminates against others in the zero-sum world of admissions. So this is where I think it's actually important that we remember that the court was faced with a specific case, not just their opinions on affirmative actions writ large, okay? And too often we see the Supreme Court as basically whether it's in 2015, are you for or against gay marriage? Decide. Are you for or against abortion? Decide. Are you for or against X, Y, and Z issue? Decide. That's not really what's happening. In each case, the Supreme Court is being faced with a specific case. In that case, you have facts, okay, of what happened, and you have an alleged harm or injury that is being done, okay? And the Supreme Court is ruling on that case, and frequently it has larger, wider implications, but they are ruling on a specific case. And so in this case, it was brought by a group called the Students for Fair Admissions, the SFFA. And they argued that the race conscience policies of Harvard and UNC discriminated against Asian Americans. And the factual findings, especially in the Harvard case, but really in both, they are brutal in these cases, meaning that they made it so blatantly obvious that how little they cared that their admissions policies discriminated against Asian Americans. And that's really what is at the root of this case, is did their race-based admissions policies discriminate against Asian Americans? So this is from the Dispatch, and this just gives you a sneak peek into some of these factual findings that were involved in this case. So this is talking about Harvard. The school learned in 2013 that its personality score, so this is part of the admissions process to get into Harvard. You had a holistic approach, so you had these test scores, but you also had what is called what they called a personality score. Okay, so the school learned in 2013 that its personality score, measuring traits like likability and courage, consistently rated Asian applicants lower, but they did nothing about it. Now, I just pause there for a second and imagine if a school had learned that something called the personality score that they assign different and potential future students, they consistently ranked and rated African American students lower. There would be outrage upon outrage if that happened. People would be screaming that this is a biased test. Or that the people involved were biased, or whatever it is. People would be screaming from the rooftops that this was racist. This is what was happening at Harvard, except for Asian students. They would be interviewed, and the people doing the interview would basically rate Asians lower, intentionally or not intentionally. Nonetheless, the school learned about it in 2013 and decided to do nothing about it. They were systematically lowering the personality scores of Asian Americans, which then, because that was taken into account whether they admitted the student or not, was disproportionately impacted Asian Americans. And the school knew this, learned this, was a common knowledge, and did nothing about it. Not only that, but Asian students also needed a higher SAT score than students of other races to be considered for a recruitment letter correlated with higher admission rates of admission. And a Harvard admissions officer laughed along with a government regulator's email joking about the school having higher standards for Asian applicants. Okay? And let's keep in mind here that Asian Americans are a minority group in the United States that also have a history of facing prejudices and discrimination, whether it's the Chinese Exclusion Act, whether it's Japanese internment, whatever it is, okay, there's a long history of Asian discrimination in this country, and that group is being discriminated against, okay? This isn't a white versus black. This is a minority group, in this case, being discriminated against. And the Supreme Court rightly saw that discrimination as, you guessed it, discrimination, and ruled that discrimination is illegal according to the Civil Rights Act and the 14th Amendment. I simply do not see how you can view this case any other way as rightly decided. I mean, it is, I do not understand how it can even be argued that this is right or just or anything except for discrimination against a minority group. It's just, to put it frank. Now, the question, though, is how broad is this ruling, right? Does this end all affirmative action policies in the workplace and for colleges, and how broad is it? Does this just say that, yeah, Harvard really messed up, UNC really messed up, but we'll see about future cases? So how broad is it? And it's hard to tell, to be frank. In the ruling, John Roberts wrote, quote, "Nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life," he wrote, "be it through discrimination, inspiration, or otherwise." Okay, so in other words, a student, maybe provoked by an essay topic or something like that, could talk about their race and talk about how their race has played into their experience or what they believe or their life in some way. However, he goes on, so in some ways you can see, okay, so, well, then can't the colleges just ask about an applicant's race? He goes on, but the institutions, quote, "may not simply establish through application essays or other means the regime we hold unlawful today." So in other words, they can't just write an essay prompt where they then have the applicants talk about their race as a way to evaluate their race without evaluating the race. So the question really becomes, and here's the reality, is the universities across the country are going to try and get clever about finding workarounds. So it's going to be interesting to see not just how they kind of think of these creative workarounds, but also how the court rules about those workarounds. Moving on to 303 Creative LLC versus Alinus. So I'm going to be a little more quick on this one, even though I think it's just as important, but religious liberty was really at stake here. Lori Smith wanted to expand, she was a graphic designer, wanted to expand her graphic design business to include services for couples seeking wedding websites. This is similar to kind of the Masterpiece Cake Shop issue in Colorado years ago. Basically, do Christian artists and Christian businesses where they express themselves, do they have to provide services to gay couples and for gay weddings? So she did not want to be forced to create websites celebrating gay marriage, but she was worried that she was going to be by the Colorado Anti-Discrimination Act. And this is where a couple of these facts that were kind of assumed in the case are important. So first is Miss Smith, that's again, Lori Smith, quote, this is from the decision, "is willing to work with all people regardless of classifications such as race, creed, sexual orientation, and gender, and will gladly create custom graphics and websites for clients of any sexual orientation. She will not produce content that contradicts biblical truth regardless of who orders it." Okay, so that was at the very beginning in the syllabus of the decision. Essentially, that this was a fact that was assumed by both Ms. Smith, the court, and the state. So everybody in the case involved agreed that she was willing to work with anybody. She just was not willing to produce content that contradicted biblical truth. And that wasn't just limited to gay weddings. That was that was all-encompassing, right? So anything that she viewed as contradicting biblical truth, she mentioned things like promoting hate or being unkind or anything like that, that she viewed as contradicting biblical truth, she was not going not going to do, and as long as it didn't involve a wedding specifically or things that contradicted biblical truth, she would serve and accommodate people regardless, including gay couples. So one of the questions involved in this was, is her graphic design business a part of her kind of individual artistic expression? And the court found that yes, it is. That each website, each graphic design she made, that there were messages that basically were inherent in each of them. They were both, they were all individualized, they're creative, they were her means of expressing herself. And so as a result, it was speech that was protected, and that the government of Colorado could not force her to say things, to express herself in such a way that she disagreed with. This opinion was written by Gorsuch, was joined again by Roberts, Thomas, Alito, Kavanaugh, and Barrett, with Sotomayor, Kagan, and Jackson in the dissent. And I thought the ending of Gorsuch's opinion was something to note. Did a good kind of summary of his and I think the majority's view of the First Amendment in this case. So Gorsuch writes, quote, "But as this court has long held, the opportunity to think for ourselves and to express those thoughts freely is among our most cherished liberties and part of what keeps our republic strong. Of course, abiding the Constitution's commitment to the freedom of speech means all of us will encounter ideas we consider, quote, unattractive, misguided, or even hurtful, unquote. But tolerance, not coercion, is our nation's answer. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands." So, as you can tell, I think this is the right decision in this case. The government, the Colorado state government, should not be able to force someone to speak in a way that they disagree with. And at heart here is religious liberty, and does this Christian have to say things and express herself and in the form of her graphic design business in a way that she views as wrong? And fortunately, the Supreme Court of the United States said that she does not. Finally, Biden v. Nebraska. This case is basically the student loan case. Student loan forgiveness case. Did the Biden administration have the power to forgive $10,000 of student loan? And the opinion stated it well at the beginning, said, quote, "The issue presented in this case is whether the Secretary of Education, has authority under the Higher Education Relief Opportunities for Students, or the HEROES Act of 2003, to depart from the existing provisions of the Education Act and establish a student loan forgiveness program that will cancel about $430 billion in debt principal and affect nearly all borrowers. Does the Secretary of Education have that authority?" Roberts wrote this opinion again, joined again by Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, dissented by Kagan, Sotomayor, and Jackson. Now, what's interesting I think this is maybe the most interesting of the four cases, and what I think is not interesting about this case is whether Biden had the power to do this or not. I think it's obvious. If you read the HEROES Act, if you consider when it was passed and what was intended when it was passed, not to mention things like major question doctrine, I think it's obvious that the HEROES Act did not give the Secretary of Education the power to wipe away student loans, period, like just blanket student loans whenever he wanted. But especially using COVID, it did not give the Secretary of Education the power using COVID as the national emergency after the administration itself said the emergency was over. So the Biden administration says the COVID pandemic emergency is over, and then claims in court that these loans need to be forgiven because of the emergency that they just declared was over. I think that's absurd, but again, I don't think that's actually the interesting question in this case. I think the interesting question in this case is really about whether the states suing have standing or not. So, and this was kind of my concern from the beginning. Joe Biden and the Biden administration forgive billions of dollars worth of student loans. Who has standing to sue in that scenario? I can't just sue because I'm a taxpayer and those are my tax dollars. That's not enough standing to go to court and say I've been harmed by this decision. The colleges and universities, they got the money. They aren't harmed. The individual people who took out the loans, they aren't harmed. The government's harmed, but the government's the one that is making this call. So who is harmed? Right? And so that's really important in our legal systems. You can't just scream, I don't like this, so I'm going to go to court and I'm going to sue. You actually have to have been harmed by the thing you claim is unconstitutional, by the law that you claim is unconstitutional. You have to have been harmed. And who was harmed? So that's the interesting question, I think, in this case. Who was actually harmed in this decision? And can they sue, right? So, you have these states that are suing, and none of them, I think, really have that much standing, okay, on their own. However, and this is where things get a little complicated, but I think is interesting. You have what is called the Missouri Higher Education Loan Authority, MOHELA, M-O-H-E-L-A, MOHELA for short. And MOHELA was a public corporation created by the state of Missouri that holds and services student loans. So they were created to basically file paperwork and do kind of administrative works with student loans for people, for Missourians. I think it's I don't know what they're called in Missouri. So MOHELA receives an administrative fee for servicing student loans. Well, if the loans are forgiven, then MOHELA, this state-created corporation, no longer services those closed accounts, costing it, by Missouri's estimate, $44 million a year in fees that it otherwise would have earned. Okay, so right there, right? See, we have a harm. We have harm done. MOHELA, they have a financial. They've been financially hurt by this decision by the Biden administration. Well, then they have standing, right? But, and here's where this case is absurd and gets interesting. MOHELA didn't sue. MOHELA has the power, has the ability, has the capacity to sue, okay, as Kagan makes clear in her dissent. But they don't sue. The state of Missouri sues. And in fact, MOHELA refused to work with the state of Missouri in this case. And basically, the answer that was given is, okay, why didn't MOHELA decide to sue if they could? The person defending the state of Missouri said, it was a political decision. Okay. Well, how was the state of Missouri harmed then? Well, in the opinion, Roberts writes, quote, by law and function, MOHELA is an instrumentality of Missouri. It was created by the state to further a public purpose, is governed by state officials and state appointees, reports to the state, and may be dissolved by the state. So in other words, that the state of Missouri created MOHELA. MOHELA is a state functionality. It's basically an extension. It performs a function that was created to perform a function of the state. So therefore, by basically the transitive property, the state of Missouri was harmed. So because MOHELA was harmed, that by transitive properties, because it's an extension of the state gave it power to do stuff and exist, by extension, the state of Missouri was harmed. I'm not necessarily sold on that argument. And in fact, the dissent by Kagan kind of goes in on that argument. So this is from the dissent, quote, so MOHELA's revenue decline, the injury in fact claimed to justify this suit, is not in fact Missouri's. The state's treasury will not be out 1 penny because of the Secretary's plan. The revenue loss allegedly grounding this case is MOHELA's alone. And remember, MOHELA didn't sue. So this discussion, this argument on standing, I think is, I don't know. I think I lean to side with the dissent here, that the state of Missouri doesn't have standing, not through Mohela. Mohela can sue. Mohela has every right to sue. The Supreme Court acknowledges that. The dissent acknowledges that. Mohela can come and claim that this injures them. It harms them, and it's unconstitutional. But they didn't. The state of Missouri did. And this, I think, here's why standing is so important, is because we don't want our judicial system getting clogged by people basically just saying, I don't like this, therefore it's unconstitutional, without having to prove harm. So that's number one, why the standing is so important. But two, I think this opinion, this dissent especially, shows why I view Kagan in much higher regard amongst the progressive justices than I do the others. I think I disagree with her frequently, but I think she is by far the brightest, the most intellectually rigorous, and can speak the language of originalism and textualism by far the best. She makes almost always the most compelling arguments against the majority. So again, I don't think the content of the Biden loan forgiveness, by its content, is not constitutional. However, who has standing to sue? I'm pretty convinced, at least somewhat convinced, by Kagan's argument that the state of Missouri has no right to sue, does not have standing, neither do the other states, so therefore the case should be thrown out. And with that is it for this week. So please like, subscribe, share, and do whatever you can to make this podcast go far and wide. And I hope to see you again next week.